fun facts all.
Okay, I'm going to keep the trains running on time. Thank you all for being back in your seats. I appreciate it. We are going to get rolling with our 11 a.m. panel, the new ecology of college sports. When we set out this time to put together the program, one of the things we're striving for is to keep an interesting variety. And so we started the morning with Diddy Combs, and now we're going to talk some college football. To get us started here, our moderator today is Bryan Underwood. Bryan is a litigator in Bryan Cave's Media and First Amendment team. He's been recognized as best lawyers of America. He helps internet and media clients navigate legal disputes over content and speech, and his experience includes defending clients against high-profile defamation claims in federal court in Georgia and in other states. He's argued before the Georgia Court of Appeals and the Supreme Court. He's got a JD from the Duke Law School. He served on the executive board of the Duke Law Journal, and he obtained his undergrad education from the University of Georgia. So thank you for being here, Bryan.
Thank you, Frank, and thank you for all the work that you do, making sure this is on, everyone can hear. I've already told the panelists that they're probably better at introducing themselves than I am, so how about I go down the row starting with Rachel and let everybody introduce themselves.
Hi everyone, I'm Rachel Jones, and I am also at Bryan Cave Layton Page with Bryan. I'm a second-year associate, but I also went to the University of North Carolina at Chapel Hill, double Tar Heel, and I played soccer during undergrad and my first 2 years of law school, so I am able to talk about N.I.L. before it was enacted and after.
Okay, good morning. My name is Gaither. I'm a partner with the law firm Baker Hostetler, and I chair our sports practice. One of my jobs these days is to grow and understand and appreciate this new landscape of N.I.L. So I've been tasked with the opportunities of seeing what's going on in the world of name, image, and likeness.
Good morning, everyone. I am Cathy Hampton. I'm a partner at Greenspoon, Marder, and a neutral at Miles Mediation, and a certified NBA agent. And I am so old, how old am I, that I worked for David Stern at the National Basketball Association in the 90s, and for Ted Turner, the Hawks and the Braves in the late 90s, and I now represent the children of some of those players.
My name is David Hudson. I'm a partner at the Barrett law firm in Augusta. I've been doing media representation work, I think, for close to 50 years. I've represented the Press Association for 45 years. And somebody says, well, you might as well learn something after all of that time and share it with others. So I'm happy to do that.
Excellent. So what we hope to accomplish with this panel is give you a little flavor of how we got to our current ecology of N.I.L, a little bit about where we are and developments, and maybe a hint to some of the things that we think are coming down the line. But to start that off, Cathy, I'd like to kick it over to you. Maybe you can give us a little bit of background on how we came here. I think a lot of us are familiar with the O'Bannon suit, which is what kicked off a lot of this antitrust concerns and the striking down of saying, hey, you can't truly restrict everything about how players are paid, but what's happened since then?
Absolutely, thank you. Well, the seminal case is the Alston case from 2021. The majority opinion by Justice Gorsuch, who was 2 years ahead of me at law school again, this is showing the age, right, when I say things like that. But what's really interesting, if you have time, is Justice Kavanaugh's concurrence. It is scathing and so juicy. So I would suggest reading, you never say that about a case, right, or a court opinion, but the court case around Alston opened the door to N.I.L. That is name, image, and likeness, and it meant for the first time, and it was a unanimous opinion, which is what makes Justice Kavanaugh's concurrence so engaging, that allows players to monetize their name, image, and likeness. So think of all the years, and think of all the prohibitions. Imagine a Reggie Bush if this had been the case earlier. So this is the 2021 case that opened the door. But there have been 3 cases since then that really set the table about where we are now. The first one is House. The House case is reparations. It says to players who were in school in Division I schools while the Alston case was winding its way through the courts, that you are entitled to a pool of $2.8 billion. And that case is for athletes from 2016 to 2021. And when we talk about disparity a little bit later, I can talk about how the disbursement of that $2.8 billion is really tying into the differences you'll see across sports, across gender, and across the players who make it to the professional leagues and those who don't. So that's the House case. The second case is the Carter case. So you may have heard of collectives. Those are those entities of boosters, sponsors, alumni. The Carter case says, why can't the schools pay direct payments around athletic performance? So the Carter case opens the door so that now colleges can pay directly to students. So say, for example, in this year's transfer portal, in the past, I would negotiate with collectives. This year, I was negotiating with coaches and college staffers. So that's the Carter case. The last one is the Hubbard case. In the past, if I am a scholar and a student athlete, like Rachel, you would have to choose because there was a prohibition on how much scholarship money would be available for an athlete. So that prohibition is now gone so that if I'm a scholar and a student athlete, I now have access to both pools. But to balance that, we now have roster caps. So it'll be really interesting in the fall to see how that plays out when we start moving the roster caps. And then there's one case in the Southern District of Iowa that's percolating now called Ortega. And that one is a challenge to the 5-year eligibility rule. So those are the cases, if you're thinking about why are we here and what's next. O'Bannon starts, Alston opens the door, House, Carter, and Hubbard. That gives you the framework for now. And Ortega, I think, is the next hot one coming.
If I may, let me mention one other case because this one is based in Georgia. Georgia changed college football forever. If you're as old as I am, you may remember that on Saturday, one SEC game was permitted. Not every school, it was just one on television. One permitted by the NCAA. Now, as a result of the case, 1984 Supreme Court case of the NCAA versus the Board of Regents of Georgia, every football team can televise its game. And once that happened, the pot of gold became available for everybody. The season is over, but you remember when the season was going on this fall and this winter. There were how many games every Saturday? Scores of games, every big game. And back before the NCAA case of 1984, even the most important games against the top teams, you could only have one a week or one in a region. And now, Division I teams, Division II teams, all of the games can be televised and they all have income. And that's where the money has come from for all of these cases that have set the groundwork that you've talked about. That, compensation and the pool of money that's been assembled to be paid to the players, it's come from TV. And that's what oh, and by the way, the brief for the NCAA that went, when it went to the Supreme Court, it was written by Ralph Beard. How many of you went to the University of Georgia and Ralph Beard was your dean? Fred Davison, the president of the University of Georgia, was so impressed with Dean Beard, he hired him to be, with Lawyer Beard, he hired him to be the dean. And a wonderful guy. So anyway, that's a little Georgia background.
The Georgia background is great, and as with many things, the developments of N.I.L. began with the almighty dollar from TV deals and opening up the spigot of money to now where we are today. In the last even 15 years, we've seen a shift from Todd Gurley getting suspended for taking money for signing a few pieces of memorabilia to Georgia's previous starter quarterback going to another school for a multi-million-dollar deal. So we've seen this sea change in the last few years, and Rachel, to some extent, you lived it, because like you said, as you're introducing yourself, you were there before N.I.L. was enacted and after, and in fact, you received some. So tell us a little bit about your experience with that shift from a student-athlete perspective.
Yeah, so I got to UNC in 2018, so at that point, you weren't allowed to turn any NIL, and in fact, before every season, we would have to fill out all of these forms talking about all the money that we made in the prior year, and even if it was just training a player down the road, you had to fill it out, say, did you get this money from Booster? Did anybody at the university help you get this job? And then I also had friends that decided to actually stop playing soccer completely in college because they posted videos on YouTube, music videos, and the school said, even though this isn't related to soccer at all, you have to choose between being a rapper or being a soccer player. And so for that, once we got to 2020, there were rumblings that NIL was going to change, and at that point, I was the president of the Student Athlete Advisory Committee. And on that committee, we had 2 representatives from every team. And we wanted to see what players actually wanted. And the interesting part about that was players weren't really that interested in NIL. They were really worried about what it was going to change within the culture of the team. And especially like the smaller teams, like the field hockeys, they worried what was going to happen to their sport, because once we start focusing on the footballs, the basketballs, do these sports even exist anymore? And at that point, we talked about autographs and whether we want to be able to sign those and sell those. And the interesting part was players really didn't want to be able to monetize their autographs, because being a player at UNC, that was the part where you finish a game, you have a big win, and then you go and all these little kids are lined up just excited to see these people that they see as idols. And the thought of monetizing that was really just completely foreign to us at that point. And then you get to NIL actually being passed, and I think everybody, athletes, athletic directors, everybody, we thought that there were going to be these rules and very strict rules about what you can accept money for, and then there wasn't any of that. NIL, the NCAA was basically like, okay, you guys can make money, go do with that what you will. And people were just really interested to see how it would play out, and for me, it came at a pretty good time because I was coming off of an All-American season. And so I was actually the first player on the women's soccer team to get a marketing agent, to get an NIL contract. And for me, those contracts were very different than what they look like today. I got free protein powder. I got free Celsius drinks, which being in law school, that made me very cool with my law school friends during finals. And the most exciting contract that I had was I was able to design a t-shirt, like a t-shirt jersey, which had a silhouette of me, the scales of justice on one side, my number, and my name on the back. And that was sold in a store on Franklin Street. And my t-shirt jersey was in the window of the store next to Sam Howell and players like that. So, and I would go to school and people would just be wearing my jersey around the law school. So that was like a completely foreign concept to me as a player, that people knew me around school, but it wasn't like people were able to really wear my jersey or anything like that. So NIL was good from that perspective for me.
Yeah.
We all want one now.
Let's go.
And for those of you not familiar with Chapel Hill, Franklin Street's the main thoroughfare, much like Peachtree here is in Atlanta or Broad Street in Athens. So she had her shirt in the shop, she could see it in the window. But what we're seeing now, and Ron, this is really going to go to you. I think what Rachel's experience was is sort of what people anticipated with NIL. You have maybe some brand deals, maybe you have someone going out there and making money from Dr. Pepper ads or something. Now we're seeing full-on professionalization of college athletics. So how would you kind of talk about how, what this professionalization is looking at unfolding on the ground, for prospective schools and players?
Sure, yeah. So I love Rachel's story. And right now, what's being described up here is truly the professionalization of college sports. And when we talk about the House case said, all right, we're going to let student athletes revenue share with the universities. Now think about that just for a second. Student athletes have the same rights to share in revenue as the NFL, Major League Baseball, the National Hockey League, and now these students have an opportunity to enter into agreements with their colleges, with their universities, and actually share in those funds. So House said, all right, here's a pot of money for you. That pot of money is $20.5 million that each school has. And so each school has the ability to now say, all right, how are we going to divide this money up amongst our student athletes? As you can imagine, where the bulk of the money goes, where do you think the bulk of the money goes, that $20.5 million? Which sport? 100%. Football. Football tends to get the lion's share of that $20.5 million, followed by men's basketball, and then women's basketball, and some of the other sports as well. So that's how the money is then allocated. And so now these student athletes enter into agreements with the university. What kind of agreements are they? I'll tell you what they're not. They're not employment agreements. The universities are extraordinarily smart, clever, and they've learned their lesson. They said, hey, these will not be an employment agreement. These will not be service agreements. These agreements are characterized as N.I.L. license agreements, meaning that the school license the student's name, image, and likeness, and they provide them money for that use. So that's what it is right now. And so when we start talking about what does it look like on the ground, Bryan, I got to pick on you a little bit. We got to talk about Duke. We got to talk about Duke's quarterback, or former quarterback, Mr. Mensah. Now you have a world whereby a star quarterback who started at Tulane, left Tulane because he was encouraged to come to Duke University and play football. Mr. Mensah received a 2-year deal at Duke whereby he was paid $4 million a year. I'm going to say that again, do the math for you real fast. This young man was guaranteed $8 million to play football at Duke for 2 years. And so he led Duke to an ACC championship, so it seemed like it was money well spent. Until Miami came knocking and said, hey, we got a little money for you too. And it's believed that Miami offered him $6 million a year. So remember, Cathy mentioned Reggie Bush. Reggie Bush was disqualified. He was, USC lost all kind of games. They were banned and a host of other things. Now you have college athletes making $8 million to play football. And so that's kind of where we are right now.
Yeah.
So the $20 million pool that each school gets to divide, that doesn't come close to paying the $4 million and $8 million and $11 million.
And that's exactly right. So what happens now? Now you still get an opportunity to license your name, your image, and your likeness with a collective that can make up that difference. And so the school has a $20.5 million cap that they can't go above, but the student athlete has an opportunity to license his name, image, and likeness with collectives, with other organizations as well. No cap.
I like the commercial that Manning has. He's next to a bullpen, and he said, I'm glad I got my insurance from so-and-so, and the bull runs out of the pen, and they run around the arena, and he finally says, hook 'em horns. And he's getting millions of dollars.
Now, Cathy, you actually work with these student athletes. So what is this doing to them? What are they coming in with outsized expectations? Or, I mean, obviously the expectations keep getting larger and larger with every year because the numbers we keep seeing keep going up. So what are you seeing on the student athlete side?
My favorite is you can tell them what's in the contract and they can see the number, but until they get that first paycheck, they don't really see it. So one of my favorite stories, because I've been in N.I.L. long enough that I now have N.I.L. players who are playing professionally, and it was, Miss Cathy, you told me it was less money in the NFL, but you didn't say it was this much less. So you now have players, because of the restrictions of the rookie contract scale, that they are earning less as rookies than they did when they were juniors and seniors in college. So think about that for a minute. It is better financially for some of these players to stay in college. So how is that played out? we're having more master's degrees. So I do believe you will see more players stay in school, because that was one of the questions. Well, what would happen with this incentive? Well, we're seeing players who are staying in school, who are seeking postgraduate degrees, so we could end up with a much more educated group of players. But keep in mind, that's the NFL. That does not work in the NBA. So my NBA players, there is no incentive for them to stay in school because they are not going to earn the kind of money in college, with very few exceptions, that they could earn in the NBA. So that's the difference that you'll see in basketball and football. And then the last part is, and this is about the disparity, we're talking about aberrations. We're talking about a very small slice of athletes. The vast majority of athletes will never see this kind of money, and they are not going to play professional ball. And I want to make sure when I'm in these conversations, I'm actually on an ABA study group right now where we're looking at these issues holistically across the country. What happens to those players? And for many players, they're just trying to get gas money for a car. I want to take my partner out for pizza Friday night and go to a movie. It's much more basic. So we're throwing out these $1 million stories because they're juicier, right, and much more salacious. But for the vast majority of players, number one, they're not getting this kind of money. They're not going to play pro ball, and if they do, think about the limited window for playing. It's not like baseball where they can be our age playing. For the most part, when you're in the NFL or the NBA, those are younger sports, and so there's a limited window. So it's important to keep in mind that this isn't the norm at all.
Right. Is not the norm. Now, I do want to quickly shift gears a little bit. We had a wonderful panel just before us on FOIA and the Freedom of Information Request and Open Records Act request. Now, obviously, a lot of these deals are coming through public institutions or collectives associated with public institutions. And so there is this element here of when do these records or contracts become public records subject to disclosure? And David, I think you've got some experience here you can tell us about.
Well, this is all so interesting, even salacious about the amount of money that's being paid to these athletes. So newspapers want to know about it. And the one paper that I know in Georgia that brought an Open Records Act to try to find out the N.I.L. information was the Athens Banner Herald. And we brought the suit for the Athens Banner Herald in the Superior Court of in Athens, and we brought it in 2002. You have to remember the Georgia legislature passed the Georgia N.I.L. bill in the 2001 General Assembly, so it probably signed by the governor, whether it has signed by June, July, something like that. It doesn't automatically go into effect. And then the NCAA itself issued the rule permitting NIL contracts on July 1 of 2001. So you got the Georgia legislature said, yes, you can do it. You had the NCAA on July 1 said, yes, you can. And so all of these schools, athletes started making money off NIL. And so the Athens newspaper, and I'm sure other newspapers wanted to know too, how much are they getting? Let us see the contracts under the Open Records Act. Well, you might say, well, you'd have to sue the Board of Regents to get the contracts that have been handed over to the school. No, you didn't. Georgia runs its athletic program under the University of Georgia Athletic Association, a private nonprofit. Georgia Tech runs its athletic program under a nonprofit. That's how they, I know the Macon Telegraph about 20 years ago sued to get the salary of Vince Dooley. Another paper, it might have been the Atlanta paper, sued the Georgia Tech Athletic Association to get the head coach salary. And so that's what Athens did in this case to get the NIL contracts. The Athletic Association was the defendant. And it said, you sued the wrong folks. You got to sue the Board of Regents, which is owns and operates the universities. No, we didn't, because the Georgia Supreme Court had held in these previous cases that the private nonprofit corporation carrying out a function for a public entity is subject to the Open Records Act. And so Judge Norris, who had the case, he had a hearing. The Athletic Association moved to dismiss this lawsuit. And the first ground that the Athletic Association argued was, you sued the wrong folks. And Judge Norris said, no, we've got these cases that have been decided by the Supreme Court of Georgia, Court of Appeals. If a private entity carries out a function for a public agency, the documents in the possession of the private entity are public records. So then the next argument made by the Athletic Association is there's a provision in the Open Records Law, plus the federal law itself, called FERPA, the Family Education Rights and Privacy Act. And that act says, in many circumstances, college records, education records on behalf of an individual cannot be produced. And that was what the Athletic Association was arguing. Well, that's really not that clear. Is an N.I.L. form an athletic record? Does that show what you've been doing in school, what grades you make, anything like that? No, it doesn't. And then there's a U.S. Supreme Court case, it was called OSS versus Foul Vote. And it said to be an athletic record, it had to be stored in the registrar's office of the university or the college. And NIL records were not stored anywhere like that. They're stored with an executive at the Athletic Association. Then there was another U.S. Supreme Court case, Gonzaga University versus Doe, that says that there is no private right of action for an entity that obtained records from a college or a university. You can't sue them for it. So what Judge Norris did, he said these are some issues that are still to be developed and decided, and I'm not going to dismiss this case. We're going to let it continue with discovery, and we'll revisit these issues. Well, at that point, the Athletic Association got tired of paying its lawyer, and heavens knows that the newspaper got tired of paying its lawyer. And you know what the economic circumstances are for newspapers. The income stream is greatly diminished. So what we did, we reached a settlement. And the settlement was this. The Athletic Association would not give us the income of the individual athletes, but they would give the newspaper the total income being paid NIL to the football team, the basketball team, the ladies team, because another concern that the Athletic Association raised was whether or not giving the income of the athletes would violate their right to privacy. We had a good argument that it would not. And the argument is this. In Georgia, we had a Supreme Court case, Red and Black versus Board of Regents, and that did not invade the privacy of University of Georgia students who had to go before a panel having to do with whether or not they committed some violations of student conduct. And the Red and Black decision said that is not a violation of FERPA, that those documents have to be produced. Also, it has to be, FERPA only applies to where the disclosure of those statements would cause a violation of federal funds going to the school. and there were no federal funds going to the University of Georgia Athletic Association. So that was another argument we had. It made that an issue that was up in the air and made the Athletic Association willing to settle on this gross basis, the gross amount of funds, not individual. And so that's why the case came to an end. Now, Bryan, were you the one that was giving me an update on the success of open record cases for N.I.L. money in other states?
Yeah, we have a few cases that we've seen in other states. There's one out of Wisconsin, that's the Libet versus University of Wisconsin case. The holding in that one was that the motion to dismiss was granted for failure to state a claim, so the people seeking the records did not get it. And then you have the Dennis Romboy versus University of Utah case, and there it said the NIL records are subject to public disclosure. So like you said, really, as soon as the NIL statutes were enacted in 2021, very quickly you started to see these disputes rise up. And the outcomes so far have been somewhat split. Schools have tried different things to remedy the issue, such as privatizing the NIL record holder so that you can get around the Open Records Act. FERPA is one of the big ones that people try to rely on, and trade secrets, that's typically an exception that people try to rely on. So you have a mixed record of success. But I do want to turn to, the other panelists here, particularly you, Rachel. You were getting an NIL. What do you think about your records being made public in this fashion? Someone goes to University of North Carolina, Chapel Hill, and says, hey, I want all records of what you've been paying Rachel Jones.
Those records would be very short. So for me, and probably most people on the smaller teams, I don't think it would be that big of a deal, but I can see from like the football and the basketball perspective where you're getting paid these millions of dollars, and that can have a very big impact on the culture of your team. Just from that, who's the star of the team and who your coaches actually value more monetarily, which that wasn't a thing before. You could get that from playing time, from other factors, but now there's an actual dollar number connected to each player. And I think that can cause many issues between players just wondering, okay, do I need to go somewhere else because I'm not valued enough? And from that perspective, it's harder to come around a common goal in that some players are thinking, okay, I need to go out on a Friday night or a Saturday night and get the most points so that I can get the most money, instead of I need to go out and we need to beat this team as a team.
There's a public interest, I think, in the amount of compensation that people get paid under the state system. How many of you have read within the last 2 or 3 weeks in the Atlanta newspapers the highest paid public employees in the state of Georgia? First, football coaches, one, and then they have the college presidents at these public colleges, have a lot of medical professors at the Medical College of Georgia in Augusta, and they all are complaining, well, I had to look at the paper today and they said that I made $1,900,000, and it went down the list. A lot of it highly paid public people. I think it's in the public interest. And if you're a football player, why not?
And Kathy and Ron, what about on the perspective you all are seeing? Obviously there's competing interests here, because the institutions probably don't necessarily want all these details public. But the flip side, they might want some of it public. They want to know, hey, we're an attractive place for NIL deals. We'll pay you a lot of money.
But you got to compete.
But you got to compete. So, we have some competing interests in play. I wonder if you could kind of spin those out a little bit.
Mine will be brief. My clients do not want their information out. What student athletes are paid, they do not want to share those numbers, because for a variety of reasons, a competitive advantage. The idea that every school knows exactly what you pay your own lineman means you have an opportunity to now go in and try to poach and recruit that lineman out. And so the last thing you want to do is have all of your information, your trade secrets, or however you want to coin it, out there in the public. And I suspect, Kathy?
The only other piece that I would add is in terms of negotiation.
Yes.
So there was a time when you you could say to a player, well, I will talk to someone in the Pac-12, that's showing how long this has been, because we don't have that anymore, someone in the SEC, the ACC, and we will let them bid, because they don't know what the other is bidding. So I had one player, for example, who it was more important to have housing, because they had a family. And so they were willing to forego cash for an apartment in a very expensive part of the country. Well, now that all the numbers are out, you don't have that competitive advantage. You can't have the different leagues, the different conferences bidding against each other, because now everybody knows what everyone else is playing. So in terms of negotiating on behalf of a player, the piece that we haven't discussed is that you no longer have that edge where the person in the ACC doesn't know exactly what the person is paying in the SEC, and you have them bidding against each other. So I would say that's probably one of the downsides of it, is that you don't have that negotiating power anymore, because now everybody knows the numbers. And the other slice that is funny to me is that they can be private about money, but then their whole lives are online. So we know how much you're earning if you just post it online that you bought a Maserati. So it doesn't take rocket science for us to know how much you're earning. So on one hand, I want to be private about the dollars, but on the other hand, I'm just taking a camera and I'm walking you through the new high-rise in Miami where I'm living. So
Which you can look up on Zillow and get a
Exactly,
estimate of what it is.
exactly.
Exactly.
But what about the agents? Don't the agents know what they can tell the players? You need to come with me, I can get you this much.
Well, now you can't say that, because everyone knows the numbers. So an agent out there promising a number that's beyond what we know to be true, then that's someone who's just trying to spin wheat into gold. So I do think it makes for more transparency and for people being honest. So you can't tell a player who's 5'9" that they're going to play at Duke if they come with you as an agent. You're probably not going to be the center for Duke if you're 5'9" or Carolina, but you would be surprised at the promises that are made to players and their families so that they can sign on the dotted line. And so with this level of transparency, that makes it much more difficult for you to spin those kinds of tall tales.
And remember that we're talking about the university and what the university is actually paying the student athlete.
You're not talking about.
Yeah, the collectives themselves is a different beast, and a lot of the things that you see online, let's say you see the kind of starter kit for a top athlete is a Lamborghini Urus SUV. It's like they all have that same vehicle. It's about a $300,000 vehicle, and you think to yourself, oh my God, that's a $300,000 vehicle, that's an extraordinary cost. A lot of those are leases that are provided to these student athletes. So those aren't their cars, but it's still a value that they're actually receiving for, for their, not for their play, but for their NIL.
And we are seeing, I want to make sure we leave time for questions, but given all this, a lot of this is really chaotic. So, the amount that players are being paid is going up and up. Players are getting unrealistic expectations, perhaps, of what they can get. If the transfer portal, I think everyone agrees, is a bit of a mess, because it encourages this sort of, back and forth, like the Duke situation. So, Ron, what is, you think, one of the ways we can bring, or some of the ways that we can bring order to the system? But short of an act of Congress, which doesn't seem particularly urgent for them at the moment.
No, they're worried about measles right now. So, that's not going to happen. So, how do you bring order to a brand new system? And we talked about professionalization of college sports. If you're looking at the professional model as a mirror to figure out how to rein in how the pendulum has swung so far to the athlete side, I hate to say this out loud, but I suspect there's going to be some form of collective bargaining as it relates to the student athletes. At some point, there is going to be a movement and a push again for student athletes to become employees. And you guys may or may not remember the Dartmouth men's basketball team. They were pushing to be employees of Dartmouth. They were also pushing to unionize. And the NLRB said, you know what? You guys have a really good case for employee status and unionization. However, the administration swapped and it changed, and then the Dartmouth men basketball team had to table that because by all indication, the current administration was going to oppose it. And so we're kind of stalled as it relates to the employment status for student athletes, but at some point that is going to happen. I suspect that will be a realization that they will be categorized as employees, they will unionize, and they'll get an opportunity to collectively bargain for these things.
And in the interim, we're seeing a lot of disparity,
Yes.
between what athletes are getting in sports, between genders. And Kathy, I was wondering if you could speak a little bit about what you're seeing on that front, and maybe, since I know you're interested in touching on the AI and how that's exacerbating this.
So there are two examples of that. Remember we talked about that $2.8 billion pool? Well, there's still pieces of that being worked through the courts, so players won't be able to access it immediately, but they all have an access number where they can go online, or they can give it to me and I go online for them and I can tell them how much money they can expect to receive. So the players I have who are in the NBA are so not interested in a few $100,000. I've been told, Miss Cathy, I don't have time for that. Maybe at the end of the league, at the end of the season, I'll go and look for the number. It's in your email. I don't have time to look for my email. So a few $100,000 is not worth going to find the email that they can forward to me for me to go and access their money. Now for the players who are not so lucky, they need that money so badly that there are entities out there right now that I'm calling pawn shops. Because what they're saying to players who they know don't have the same resources, sell me your rights. So there are players selling their rights to this money for pennies on the dollar. And I have seen so many of those deals for the players who don't make it to the big leagues where they need money. So that gives you a flavor for the disparity. You have players where a couple $100,000 is not worth looking for an email, and players who need money so badly that they are willing to sell their rights for pennies on the dollar. So that's just a reminder of the disparity. And the other one is showing up in AI. For the larger programs, AI is just another tool in the toolbox, so that I can plug in a training program, I can put in a nutrition program. Do I want to gain weight, lose weight? Do I need more fat, less fat? And then you have a whole team of nutritionists and trainers who can take that information from artificial intelligence and they can tweak your whole program. But if I'm at a school where I don't have those kind of resources, I'm trying to do that myself. And I'm using AI to self-train. Well, AI may not know that your grandmother has diabetes and your father has glaucoma, so that maybe you need to have a different diet. Or that maybe you're overtraining because it doesn't know that you are not eating the way that you should and you're not hydrating. So you have players who are over-relying on AI because they don't have the resources, whereas you have other players where there's an ecosystem to support them, where AI is just another tool in the toolbox. But both of those examples give you a flavor of the disparity based on what sport and where you're playing it, and sometimes, unfortunately, your gender as well.
Absolutely. Now, before I turn it over to questions, and I want to make sure we leave time for it, I want to leave each of you with concluding thoughts, whatever you think about the current state of N.I.L, what you hope for, where you think it's going in the future, anything you want to say. I think I'll start at the end with David, and we'll work our way back this way if that works.
Well, coming at the issue from the point of view of the media, I am for more disclosure. I'd like to see on every Saturday football game that there's a signature on the bottom of the screen. Our payment to our players this year is X amount of dollars. So you can compare the Georgia payment to its players with Texas or Georgia check. It's about as important as how much do they weigh and things like that. How much are you paying for your team? You know it in the pros. You know it for baseball. Why not know it for college players? So I'm in favor of more disclosure.
I'm in favor of more lawyers being involved. So I would encourage folks who are interested in this space to look for opportunities. And you don't have to be a lawyer. There's a need for finance advisors, for tax professionals. I mentioned nutritionists, physical therapists. There are so many opportunities in this space, and I just don't see enough of us there. So for lawyers or their families, people that you know who are interested in working in the sports industry, there are way more opportunities and way more jobs that are available at all these different levels we're discussing. So I would love to see more of my State Bar of Georgia members and colleagues in these spaces.
I'm I'm slightly different. I know we're talking about NIL today, but the one thing that I'm hopeful for, looking for, is greater protection for the student athletes as it relates to gambling and gaming. Because the gambling and gaming that's happening right now alongside or in the NIL ecosystem, meaning all the money that's being paid to student athletes. You know, Rachel talked about the haves and the have-nots inside of the locker room. Imagine, you know, you got one kid in one corner who may be making $30,000, but you got another kid in another corner of that same locker room who's making $3 million. That creates opportunities for student athletes to be taken advantage of. And so I think there should be greater restraints as it relates to gaming and gambling on college sports. So.
Yeah, and my final thought is to the student athletes, or if you're a parent of a future Division I student athlete or current, don't forget that you are a student athlete. When I was there, that was a very big thing, that student comes first, athlete comes second. I know that in the papers there's all of these articles about how much people are being paid, but don't forget that that's a very small percentage of athletes. And what's going to happen when you graduate and you need to find a job? What did you do during your time where you were provided the entire world, you got tutors, you got everything? What did you do then to set yourself up for what life is going to be like after athletics?
And then we don't lose sight of all those other values that sports give us too. So we've got about 10 minutes left. I would love to see if anybody has any questions. If not, I can probe our panel a little bit more. I can answer whatever.
I'd like to hear more about the gambling component in relation to college sports and how that's playing out.
So I suspect we're familiar with the story out of Kennesaw State. If we're not familiar with it, there are a number of student athletes accused of point shaving in basketball. And one of the vehicles that's being used in these allegations is something called a prop bet. A prop bet is essentially a bet for a very specific event occurring in a game. So use basketball, for example. Player X will miss his first free throw, and if so, you can gamble on it and make a bet on that. So if you approach player X and say, hey, here's $30,000 if you miss your first free throw, will it really affect the outcome of the game that happens in the first quarter? So it may not be that big a deal. Here's $30,000. That's an extraordinary influence on these young student athletes. And so to your question, is this idea of how do we go about protecting these student athletes from that type of influence?
How do we?
The NCAA and Sean Baker have made open statements that say they would like prohibitions against betting on college sports. And so I suspect that would be one way to do it, a prohibition of it.
Hi, I have a question about the WNBA, particularly because it's women, largely black women. We certainly see some of the bigger stars seem to have made way more money in college than they are as pros, but also it does seem to be an incentive for them to stay in school. It seems like the WNBA players seem to get their degrees. So what are your thoughts about the inequities as it relates to the women basketball players?
So I believe what you're about to see is a sea change. As many of you may know, they are in the collective bargaining process right now, and it's been very public. And to your point about disclosure, that's been for the benefit of the players, because too often collective bargaining is behind closed doors. And you may have seen on Sunday nights that we're about to have more Sunday sports. So the numbers will drive much more equity because the numbers are there. People are watching and supporting and buying the jerseys. So what comes out of the new collective bargaining agreement for the WNBA really should be a signal of where sports will be going. And in terms of soccer, I don't know if you all saw Trinity Rodman and what was able to be negotiated for her, but they tried to change the numbers, but she's getting the eyes, she's drawing the crowds. You just can't deny that kind of talent and that kind of draw. So I believe what you're about to see is much more equity because the numbers are demanding the equity, the popularity is there.
Hi, I have a quick question, particularly to Kathy, but if anyone else has knowledge on this matter, I'd love to hear your thoughts as well. Can you talk a little bit about how media orgs that cover recruiting and the transfer portal in particular have affected NIL negotiations, and how much trust can other media organizations place in the valuations and things that other organizations put out there? I've seen conflicting reports that the values of these deals are grossly inflated, and others say that they're accurate. So I'd just love to hear your thoughts on that, especially from all of your perspectives. Thank you.
Yeah, so the question is the actual valuations of some of these NIL deals, and I don't know how to answer that. The accuracy of it, given the fact that some of the money is coming from universities, I think that's relatively accurate. However, the money that's coming from the collectives, we just don't know the accuracy of that. One, because a lot of that is, as I mentioned, in kind, meaning I'm going to give you the
apartment,
yes,
the lease.
exactly, the lease or the apartments, the cars, and the rest of those things. So it's hard to truly quantify what's going on.
And sometimes the numbers will be based on what the athlete is willing to do. So they can see the number for how many trading cards, but once they sit there and they start signing hundreds and thousands of cards, and they can feel the difference, and I've had players tell me that, I can feel the difference in my wrist is happening. So yes, there's a potential to earn so much, but they may decide it's not worth it because I can feel it in my wrist. So to your point, there's a range of the money that they can earn based on how many autographs, for example, they're willing to sign, but we also want to make sure that we're honoring their bodies and how they're feeling so that they can say, I've signed enough, and I can feel that in my wrist, and it doesn't feel really good. So yes, they have the potential for earning so much more, but sometimes the body, or sometimes the academics, and what it is that they need to do in the classroom say no. So to your point about what it's worth, it's really going to be determined on how much and how available a player can be, for example, to sign memorabilia.
My question has to deal with the capacity, because these are young guys, some of them are old, and some of them don't get the right advice. People get to them, they sign contracts that maybe they shouldn't sign, it's too long or whatnot. That's legally, what can be done about educating them or getting them out of contracts they shouldn't have signed?
This is not precisely, but it relates to it. The Georgia legislature is now considering a bill for restrictions on N.I.L. for high school players. And one of the requirements of that bill is if you have an N.I.L. contract, once you graduate from high school, it's over. It doesn't apply, it doesn't follow you to the pros, it doesn't follow you anywhere else. Then you get to get you an agent and do it all over again.
Any other thoughts on that? Other question?
This might be off topic, but Trinidad Chambliss, and it's my understanding there's litigation going on about him going back to Ole Miss. Do you know what the argument is for him to continue to play college football, like what the legal arguments are?
So I think it's an unreasonable restraint of trade, same as the ones we've been dealing with for.
And it also goes to the Ortega case that I mentioned too, in terms of your years of eligibility.
Great, yeah.
So it will be interesting to see how that one works its way through the court, because everyone wants to see more good play, and you want athletes to have the full value. At the same time, you want athletes to move on so that the younger players behind them can come along as well. And so the question is, what will the market allow? And what I can imagine is by the time they weigh it and figure it out, this particular player will have moved on, but then it will apply to other players, which is usually what happens. That was the case of Hosanna, who kicked this off for us.
Okay, thank you.
Was it to give him his 6th year to play at Ole Miss?
I don't remember if it was his sixth or more.
But who's counting, says the person from Mississippi.
So I kind of want to go back to a question similar to the one that the gentleman before last brought up. So right now, we're on the topic and discussion about college athletes and their rights. And Ron, I know you mentioned it's probably headed towards an environment where college athletes are probably classified as employees and collective bargaining and setting wage scales like we have in the NFL and the NBA. Where does that line stop, right? Because someone mentioned earlier, you have a ton of Georgia high school coaches that are making hundreds of thousands of dollars. Does the line stop at college? Do we consider high school athletes then to become employees as well? Because yes, they're not putting in the same level of time and dedication and effort as your college athletes, but they're still putting in significant amount of time. They have the educational requirements as well. Like, where do you guys see that line stopping?
From my own perspective, I see the line stopping at the high school level, meaning I have a family member right now who's going through the process, highly recruited athlete from Cobb County, Georgia's looking at him, Oregon, you name it. But there is a genuine appreciation for the fact that he is a high school student. Right. And I think that's where it stops. And when we talk about the NCAA, we have to acknowledge just the sheer volume of money that's inside of this program. And you mentioned the coaches. Someone was talking about the coaches. Since December 2025, the number of coaches who have been separated or terminated, the dollar amount paid to those coaches to stay home is $228 million. To stay home, don't come close near a field, we're going to pay you $228 million. And since the last 10 or so years, that number is estimated close to $900 million paid to coaches, NCAA coaches, in payouts, buyouts, and the rest of those things. And so I think just the sheer volume of money and just the professionalization at the NCAA level, I think that is a line of demarcation right there.
Thank you.
And with that, I'll turn it back to Frank.
Yeah, Bryan and panelists, thank you so much. Let's give them a hand. Well, I hope everybody's found this as interesting of a morning as I have, and we're going to keep the momentum going. So if everyone will, your box lunches and beverages are out in the lobby where you registered. If you want to go ahead and help yourself to that, get back in your seat. We'll try to get our next panel, which is all about news media coverage of the immigration system. And we've got some excellent experts to share their experience about that. So please be here at 10 after the hour, and we'll get started. Thank you again.